Receiving a refusal can be frustrating, but it's important to know you have options. This guide will walk you through the planning appeal process, helping you understand if you should appeal, how to prepare, and what to expect along the way. Grounds for appeal. You can appeal in 3 situations. Your planning application was refused. Review your decision notice carefully. It outlines reasons for refusal and is key to your case. Your application was approved, but with conditions you disagree with. You can appeal against specific conditions while accepting others, so be clear about which conditions you disagree with and why. Or, if you did not receive a decision within the statutory time period. Before appealing, check with your local planning authority. There might be a simple explanation for the delay, or they could be close to making a decision. Is an appeal right for you? Before starting an appeal, there are crucial factors to consider. Time and resources. Appeals typically take several months, and complex cases can take longer. You'll need time to gather evidence and prepare documents. While there's no fee to appeal, consider potential costs such as your own expenses, professional fees if needed, possible liability for other parties' costs if you act unreasonably. Alternative solutions. Submitting a new application may be more suitable than appealing. Speak with your local planning authority, as many issues can be resolved through conversation, and they might suggest acceptable modifications. Remember, in most cases, you won't be able to submit new evidence. Strength of your case. Ask yourself, can you effectively challenge each reason for refusal? Do you have clear, planning-based arguments? Is your evidence strong enough? Would you benefit from professional advice? Critical deadlines. Make sure you check the deadlines set out in the decision notice or on gov.uk. As different applications have different time limits, knowing your appeal deadline is critical. Miss it, and you'll lose your right to appeal. Deadlines are absolute. We only accept late appeals in exceptional circumstances. Remember, an appeal is a formal process and the last resort. The inspector's decision will be final, and you can only challenge this decision through the High Court. Preparation. Eligibility. When you make your appeal, we need to confirm you have the legal right to do so. Only the person who made the original planning application can appeal, and their name must match the original application exactly. If you're using an agent, the agent can submit the appeal on your behalf, but the appellant must be the original applicant. Don't put the agent's name as the appellant. This will invalidate your appeal. Documentation. In most appeals, you'll need your planning application form. Please check all pages are included. The decision notice showing reasons for refusal. And your statement of case, which must include a written explanation of why you disagree with each reason for refusal. Focus on explaining why your development would be suitable for the area and how it meets local guidelines. Keep to practical reasons rather than personal circumstances. A brief, clear, well-organised argument is best. You don't need to repeat information from your original application, as the inspector will already have this. The local authority will provide us with drawings and plans that were considered as part of the application, as well as any supporting documents like surveys or reports. Where we ask that you provide further details or evidence, always include a numbered index listing every document you're submitting. Think of it as a contents page that helps everyone quickly find what they need. We can't start processing your appeal until everything is submitted correctly. Missing or incorrect documentation will delay your appeal. Making your appeal. Your appeal can be handled through 3 procedures: written representation, hearing, or inquiry. We will ask you for your preferred option, but we'll make the final decision based on your case. Appeal procedures in detail. Most appeals are handled through written representations. The inspector will decide the outcome of your appeal based on the evidence you provided in your original application, along with the council's report and decision. Where it is necessary to submit further evidence, the council will have the opportunity to respond, and interested parties are given the chance to comment. Hearings are a structured discussion led by the inspector. Everyone sits around a table, key issues are discussed in detail, and questions can be asked and answered. It's less formal than an inquiry and is used to clarify matters or test evidence through questioning. Finally, inquiries. This is our most formal procedure and is much like a court proceeding. Expert witnesses are typically involved, and lawyers are often present too. Inquiries are usually for complex planning issues, cases with significant public interest, or technically complicated matters. In all 3 procedures, the inspector will visit the site and make a thorough assessment. Submission process. Once you're ready, you can submit your appeal online at gov.uk. Make sure you upload the correct documents and pay attention to file size limits. Name your files clearly. And structure your submission sensibly. Start with your application form and decision notice, then your statement of case, then any supporting documents, if required, in the order they're mentioned. After submission. Once you've submitted your appeal, the validation process begins. The Planning Inspectorate will check your submission thoroughly. This usually takes about a week. You'll receive confirmation of whether or not your appeal is valid. If it is valid, a case officer will be assigned to manage your appeal. Next, the local planning authority will notify everyone who needs to know about your appeal, including neighbours and anyone who commented on the original application. We'll arrange a site visit and hearing or inquiry where relevant. Dates and any specific requirements will be shared with you, and you will be notified if the inspector needs to be accompanied on the site visit. Make sure you keep your appeal reference number handy, as you'll need it for all future correspondence. Depending on the appeal procedure, there may be delays due to high case volumes, complex technical issues, site visit arrangements, or public holidays. Check our page on gov.uk for typical appeal handling times. Outcomes. Your appeal might not be determined if there is invalid documentation, the procedure was not followed correctly, you submit late documentation. If your appeal is determined, then possible outcomes are appeal allowed, appeal dismissed, or allowed in part. Appeal allowed. Planning permission has been granted and development can proceed. There may be conditions, so be sure to read your decision carefully. Appeal dismissed. Permission has been refused and development can't proceed. In this case, you may need to submit a new application. Allowed in part. Some elements have been approved and others have not. The inspector's decision is final. All parties will be notified and the decision will be published online. You can only challenge this decision through the High Court on legal grounds. At the Planning Inspectorate, we want a fair and transparent appeals process for everyone. Only appeal when you have a strong case. Remember that the inspector will make their decision on the same basis as your original planning application. Prepare thoroughly and meet all deadlines. Keep clear records and communicate professionally. Follow the process carefully from start to finish. If you need more information, visit our website or speak to your local planning authority.